Good morning. Can I welcome everyone to the 15th meeting, it seems much more, of the Justice Committee in 2013. Can I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when they're switched to silent. Apologies have been received from David McCletch, whom we give our best wishes to, by the way. John Lamont is attending as his substitute. Item 1, decision on taking business in private. I'm inviting the committee to agree whether to take items 5, 6 and 7 in private. I'm going to explain why. Item 5 is being proposed as a private item as it involves initial discussions on the committee's draft Stage 1 report on the Victims and Witnesses Scotland Bill, including possible recommendations, and it allows, as we know, clerks and others to comment, as well as us to come up with our themes. Item 6 is consideration of our approach to reviewing the provisions of the Police and Fire Scotland Act 2012 relating to the Scottish Fire and Rescue Services being proposed a private item as it will involve a discussion on potential witnesses. And finally, item 7 is consideration of a draft report on our inquiry into the effectiveness of the provisions of the Title Conditions Scotland Act 2003. Again, it's a draft report and it would allow free discussion and intervention by the clerks. Are members agreed we take items 5, 6 and 7 in private? Agreed. Item 2, Victims and Witnesses Scotland Bill. It's our final evidence session of our Stage 1 inquiry into the Victims and Witnesses Scotland Bill. And I welcome to the meeting the Cabinet Secretary of Justice, Kenny McCaskill, Graham Ackerman and Gary Cox, both from the Criminal Law and Licensing Division of the Scottish Government, and Craig McGuffey, a Principal Legal Officer in the Scottish Government. Could I move straight to questions from members, please? Alison.
Thank you very much.
Colin and then John.
Good morning, Cabinet Secretary. I'd like to explore some of the provisions that are in the bill for vulnerable witnesses. I think generally the extension has been welcomed, the extension to other categories, but we have received quite conflicting evidence on the provisions that are in the bill that would allow a challenge to those special measures. We had victim support arguing that allowing the challenge to special measures was its greatest concern. And we also had the Faculty of Advocates, among others, saying that the accused lawyers must be able to challenge. Do you think the bill does strike the right balance between the victims and the accused?
I thank you for raising that, and I think it's an important point, and we've taken on board, I think, the concerns that have been raised with you, and I think you're quite correct to articulate it. We do require, I think, to go in this direction with the EU directive, but it's a matter that we're more than happy to engage in discussion with the Crown Office and Procurator Fiscal Service to make sure that we get the balance right. It is a matter of balance, but I think the points raised do cause us some concern as well, and it's a matter that we're going to discuss and liaise with the Crown.
Will you also liaise further with Victim Support Scotland?
Oh, absolutely.
Yes.
That's read.
Are you able to tell us in what circumstances you think objections to the standard special measures might be lodged?
Well, we would think that these things should be on a not on a regular basis. I think it's really a matter, to some extent, why we have to have the involvement of the judiciary and the courts, but it's about getting the correct balance. I think the standard that the issue that we can particularly think of might be, for example, a gang fight type scenario where the accused could be under 16, but not significantly. He could have, or sometimes sadly even she, could have known those who were involved. So there are instances where I think it might be taken as being a situation where some variation might be appropriate.
Do you see it being used in quite limited circumstances?
I tend to think so. I think we should try to provide the protection that is the basis and the ethos of the bill. We do have to, and I think the convener has commented on about, we do have to weigh in the scales of justice, not just the rights of the victim, but the rights of the accused. But in the main, we're here to provide protection and support for those who have to deal with matters that are very stressful.
If I might, Convener, the evidence that we heard from those representing victims and witnesses, they're at pains to ensure that these people are able to give their best evidence, and they felt that the uncertainty that would arise from the possibility of an appeal would actually cause greater upset than is currently in the system at the moment. Can you explain the time scale for an appeal and how that would be carried out?
I don't think we're able to go into specific details unless Graham can help me out here. I think I'd take the view that these matters, because I think the point you raise is quite valid, it would create uncertainty, but we do have to balance the right of the victim with the right of the accused, and there will be instances where these challenges will come in. I do think, in my experience, we already have similar type matters that are dealt with within the court. They're always accelerated, and that would be the general intention of travel that we would have, so that there would be some certainty and it would be dealt with quickly, not simply for the accused, but indeed for all those involved, including Crown and Defence. But Graham, are you able to?
Yes, I mean, in terms of specific timings, any party proceedings can lodge an objection notice no later than 7 days after a vulnerable witness notice or application has been lodged. The court can allow later objections to be lodged if it thinks that's appropriate under the circumstances. It's worth noting as well that existing provision in the Criminal Procedure Act 1995 allows the court to review special measures once proceedings have started, which I know is the subject of discussion at a previous committee session.
Okay, Colin, followed by John Finney, then Graham. Colin.
Thank you. Good morning. There's been a number of questions raised about the idea of victims and witnesses participating effectively, set out in the principles of Section 1 of the Bill. Could the Cabinet Secretary explain what's exactly meant by this principle?
Well, we're looking at a very high level. That, I think, was the direction of the EU directive. We clearly wish to engage with Victim Support Scotland and Scottish Women's Aid, Rape Crisis, as well as clearly in other matters with those who represent the accused, such as the Law Society of Scotland and the Faculty of Advocates. But the involvement here is at a high level in terms of discussions that take place on a very regular basis between government officials, other aspects of the judicial system in terms of Crown and Police Scotland. So it's at that level, although I do know from experience, and it'll probably be aware to community members, that clearly that filters down with courts having user panels, and indeed I know from discussion with the clerk at Edinburgh that they are discussing and engaging with those, for example, who have been the victims of domestic violence, so that they can work out on a practical measure what the user experience, if I could put it that way, has been, or perhaps more likely should be.
Really thinking in terms of raised expectations as to those who have been victims or of crime, that they may think that what has actually been an offer here in terms of effectively participating, their views might be assumed that they might think they have a bigger part to play than perhaps they have on a personal level.
I don't know. I mean, I think, the whole ethos of Scots law has been that you take the victim as you find them. And I think we have to aspire, in terms of the legislation and the, not just the legislation, but the directives and protocols we lay down, to deal with matters as best we can, which is why there's clear matters and expectations for Crown, for the court service, and I think that's how it should be. Equally, I think we've got to remember, as I said, that we do take the victim as we find them. Victims come in all shapes and sizes, they have all different needs, and we've got to have that element of flexibility. So what's intended here is that we engage at high level, so that as the terrain changes, as needs arise, as problems are brought to our attention, all those involved, not just government, but those in the court service and the Crown and the police, are able and I would expect willing to engage. But equally, we've got to allow the flexibility to take account of the particular needs of the individual when a situation arises, and that's what we hope to achieve.
Thank you, Colin. John Finney, Graham, then Sandra.
Thank you, Convener. Good morning, Cabinet Secretary. We received a letter, Cabinet Secretary, in response to a matter we raised with Police Scotland, and the matter was about the level of information routinely provided in Sheriff Courts in relation to bail cases. And if I quote what Police Scotland have said to us, this is just in, police officers will highlight to the Procurator Fiscal any significant concerns they have that the quality of evidence given by the victim or witnesses will be diminished by any fear or distress in connection with giving evidence at the trial or proceedings. In addition, officers will also highlight the reaction of the victim or witness to the crime or to the accused and any personal any personal characteristics exhibited by the victim or witness which might suggest vulnerability. which sounds very good, except they go on to say, in such cases it is not the role of the police to conduct a formal assessment of the victim. So are you able to say that there is a reference to guidance provided by the Lord Advocate? Will that guidance be reviewed? Will there be training? And whose responsibility is it to provide the formal assessment of the victim?
Well, guidance from the Lord Advocate would obviously be for the Lord Advocate here. And I think, first of all, I think the police are quite right. That information should go, but clearly there are limitations in what individual officers should mean, are able rather to do in terms of the skills and resources that they have. The general principles of the bill are that each and every body that is dealing with matters, whether police, Crown or indeed court service, should obviously be addressing and making an assessment of the individual witness and trying to meet wherever possible their needs and requirements. So I'm certainly happy to feed back to the Crown. I would imagine that the Crown will be dealing and reviewing with these matters, and clearly they have their own procedures there. I would have thought it almost certain that they would require and would be seeking to vary their guidance once the new legislation goes through, but I'm more than happy to get further information for you on that.
Thank you. Can I move on to other matters? Yes. Convener, please. My clairvoyant skills are not with me this morning. But, I wonder if you could clarify, Cabinet Secretary, would it be your understanding that it would be permissible for any defence agent to challenge any aspect of proceedings at any time, regardless of the consequence of this?
I'll defer to Graham on this. I would have thought probably yes, other than spurious challenges, and we would have the good sense of the judiciary to act. But Graham?
Yes, I mean, in terms of the provisions around objections to special measures, the bill states that objections can be raised about the particular circumstances of the case, about the special measure that's been granted or there's been a notification has been sent in on. The grounds for that objection are not stated. The bill does state that the defence or any party proceedings must set out what grounds they're objecting on, why they feel the special measure is inappropriate in those circumstances. And as the Cabinet Secretary says, it would be to the court, the judiciary, to decide whether there was merit in that.
And equally, I can give you an assurance that we and I will be liaising with Sheriff Tom Welsh at Judicial Studies to make sure that these matters are brought to attention. I think I cannot think of a way that we could preclude matters as such, because we're not, as you say, clairvoyant, but we do rest in the good sense of the judiciary. The same in terms of how a witness is cross-examined. Sometimes, as you'll know from experience, firm questioning has to be allowed to take place for justice to be done. Equally, when it is clear harassment, then we expect, and I think the judiciary would act to rule out the direction and the manner in which it's been carried out. But I can give you an assurance that we'll be liaising with Judicial Studies to ensure that the outstanding work that they're doing will also take into account the necessary knowledge and information that they'll wish to provide to judges and sheriffs.
At the risk of further poaching?
Well, we'll find out. Yeah. I'm not clairvoyant either.
Okay, thanks. The issue of oral representations made by victims and their families to the parole board further down the line. Can you just confirm what we heard from the parole board Cabinet Secretary, and that is that these representations would be made available to the prisoner and they would be open to challenge?
Would you be able to?
Yes, that's correct. I mean, it's worth making a point that this isn't a massive departure from what happens at the moment. The written representations can be made to the parole board currently. Those written representations are included in the dossier that's sent to parole board members, and that's also made available to the prisoner, who then in due course can make representations to the board about those. In the case of oral representations, again, the victim would be making oral representations to a member of the parole board. That would then be put into an agreed statement, which again would go into that dossier, and the same procedure would be followed.
Thank you very much. Thank you, Convener.
Graham, we're about to find out whether any of your questions have been poached.
You've covered the areas very, very well so far. Can I stay with the oral submissions first and foremost as a supplementary? What kind of format was it imagined that these oral representations would be received? Would someone go to the victim's home, or would there be arrangement? Would they have to go to the prison? How was it envisaged this would work?
Well, we've tried to be flexible in this, because the original idea, I think it came from Margaret Curran in the past Parliament, and indeed it was also suggested it might have been by Margaret Smith, to their credit. What we've tried to avoid is the situation, because clearly people wish to make representations, and we did not wish to have a scenario that we'd have had the victim having to go to the prison, that we'd have had them being subject to cross-examination by the prisoner and his agents, and unfortunately in terms of ECHR and fairness, that's where we would have gone. So we've been discussing with the parole board how we can allow these, I think, appropriate representations and vital representations to be made by the families without them having to endure that. Some of this will have to be worked out with the parole board. I cannot imagine that it would be in the prison for whatever reason, whether it would be in the victim's home, whether it would be in an office. I think some of these things I would have to say we'd probably be happy to allow to be worked out in terms of what is best for all parties within reason. But there would have to be some balance between formality for the benefit of the parole board being able to appropriately record it. But as I say, the driver to this has been to allow the victims' families to make their representations, but to avoid A, going to prison, and B, be subject to cross-examination. But Graham, I don't know if there's anything you wish to...
No, that's absolutely right. I mean, we've had discussions with Parole Board about this. I know when they were looking at the costs for the financial memorandum aspect of this, they thought there probably would be some travel involved for Parole Board members, that perhaps a neutral location would be chosen. But again, their concern is really on making it easy for the victim and making sure that, as Cabinet Secretary says, they don't have to go to a prison or have that overly formal process.
I think I would want you to note that certainly in the evidence given to us from the prison service, they didn't feel they had the environment or the necessary arrangements to cope with such an oral representation within their environment. And I think that needs to be borne in mind in whatever arrangements. In that connection, the VNS system, there has been a number of representations made, certainly to me in emails and letters, that the experience of VNS is not particularly helpful, and that witnesses, victims, families and so forth feel they need to pursue information and to chase after updates and so forth. And equally, years later, the sudden shock of correspondence arriving at their doorstep to indicate that there's a new phase in this environment is to be intimated, they find very hurtful and take them right back to the start of this terrible saga again. And the third thing that's been mentioned is not knowing where the prisoner is and what the intentions might be subject to decisions that are taken by the parole board. There's nothing within the Act which would seem to deal with these issues. Would it be your intentions in policy terms to make sure that these sensibilities are fully considered and properly addressed?
Absolutely, and I think we do recognise that there are difficulties. I think it would be fair to say that I think the VNS scheme is in the main very much welcome. There are difficulties and sometimes challenges, and have been brought to me because sometimes people have been released and it's caused a great shock, but the scheme had to start somewhere, and there are people who are released and predate the scheme, for example, and that causes distress, and that's not a fault of the scheme because there had to be a start date and matters follow thereafter. There are obviously some matters over which the prison service is restricted, and matters have to be dealt with in terms of legislation and guidance through the parole board. I think what we're trying to achieve in the bill here is first of all to deal with the matter correctly raised by Margaret Curran, to make sure, as we gave in that undertaking, as we did in the previous Parliament, that we had to get the balance right, that the reason we couldn't go down this automatic right would have been to the scenario you play out of having to go to the prison, which is inappropriate, never mind the consequences thereafter. Some of these matters will have to be dealt with through other aspects, such as the parole board and how they look at that, but certainly our intention is that wherever possible, as much information should be available. There'll be some information, given that people have to be released in the main in most instances, and they have to have some rights to do it, but equally we have to protect individuals, especially from those where clearly there may be, as I say, a clear likelihood that they would be running into each other. But Graham, have you got any further matters from discussion with the parole board?
No.
A more substantive issue from my own viewpoint that I've got particular interest in, we've received very powerful evidence from all our victims concerned that, as I've described at a previous meeting of the committee, they felt like a parcel in the post, constantly being readdressed and going over their various elements, their name, what their crime was, what their background is, constantly telling people and reliving. So within the environment, as Cabinet Secretary knows, we've got the police, VIA, victim support, Procurator Fiscal's Office, Crown Office, the court service, defence agents, all of whom operate individually, no doubt well-meaning, but at the end of the process, our victims, our witnesses are bruised and left very often deeply concerned at how they've been treated. There has been mention of case companions previously, and I'm not suggesting that I would want to see case companions introduced at this stage, but was it thought that somebody within the system should be seen as the key link with an individual so that other agencies wouldn't need to constantly go back to the victim and take them through all the basic stuff yet again? The bill doesn't seem to address that, and that seems to be a major issue for the various victims.
No, I think I should first of all state on record, I mean, the reason we're bringing the legislation is not simply the EU directive, but we know that more needs to be done. I think it would also be fair to say that we should recognise the considerable progress that has been made. I think to the eternal credit of a previous Lord Advocate, Dame Eilish Angelini, she identified this before even I came into administration. And I think great progress has been made, but we still have to go further. And to the credit of the current Lord Advocate, he identified that it's not just victims, it's witnesses, because that too can be stressful and difficult, and that's why it's a Victims and Witnesses Bill. We do live in an adversarial system, and as a consequence, sometimes things have to be done and victims have to endure things because that's the nature of how their evidence has to be tested, and they have to be dealt with both by police officers, then by Crown, because there are different roles and there have to be checks and balances. They have to be allowed to have their evidence led in court because it has to be often put before if people are pleading not guilty, and indeed it has to be tested in cross-examination. We believe that there's, case companions aren't necessary as such, that we have already family liaison officers, where police, I think, do an outstanding job with 2 officers being identified and deal with matters. The Crown have systems in which they seek to lock on. Victim Support Scotland are there, as are others, whether it's Rape Crisis or Scottish Women's Aid. Some of this is about making sure that the individual victim gets the support that they need from the appropriate authority. I don't know if there always has to be some element of people representing the particular agency because there's data and protection and other issues. But I think the concept of people having support through the system is vital, and you're quite correct to state that. I think the police have recognised that for a while and are doing so with family liaison officers. The Crown have recognised it, the court service have recognised it with walkthrough in terms of victims who are wondering about where the evidence will be and how it will give. So I think all those matters are there, and we do of course have Victim Support Scotland and other agencies. So I think the case companion is in concept already there. It's just the individual should be able to choose which person they want, and I think the organisations equally have to recognise that they've got a role to do, and they have to progress the work in terms of putting the case before the court or leading the evidence in court, but they've got to bear in mind the rights and indeed respect that they've got to give to the victim.
I mean, before moving on to my last question, if I could, it's not so much the adversarial situation within court that they complained about, although many of them found that quite harrowing. It's a handover between agencies. It's the apparent reception by a new player as if this witness or victim was unknown, and they had to go through almost from day one the whole process of why are you here, what are you complaining about, where do you live, all that kind of stuff. It's that inability to carry through all the kind of basics that would ease away for them. And, even when they appear at the court to give evidence, someone meeting them at the court that doesn't seem to know who they are, what they're involved in, what arrangements have been made for them. So it's some of these bits that they gave evidence on, which was very impactful in listening to folk who were already going through a very difficult experience on behalf of their families.
I don't rule anything out. I would just, and I think I accept the point that you're coming from, but I wouldn't want to cut across the role that we currently have of Victim Support Scotland, Women's Aid, Rape Crisis Scotland, because in my experience, and doubtless even more so in yours, reference will be made by the police to many of these organisations at the outset. Indeed. And what I wouldn't want is a scenario where somebody was told, you can't see Mr X because in fact, or you can see, but we're sending you to Miss Y. So to some extent, if it's felt by, you know, a new agency should be created, we'd be happy to look at it. But I think what I can give you an assurance that what we'll get out of this is, hopefully, because we all know that sometimes things fall through the cracks, not through you know, design, but through accident, things don't work out. But if we can make sure that through Crown, through police, through the good work with family liaison officers, that where people need Victim Support Scotland, Rape Crisis Scotland, Scottish Women's Aid, and I think they provide a case companion, because some of these things are case and crime specific. I think the work that Rape Crisis do, for example, is outstanding. It is deeply specialised, though, and somebody who is perhaps more generic in terms of dealing with a case companion might not be able to provide the care and support. So we rule nothing out, but I think the view that we're taking is we wouldn't wish to cut across the bows of organisations that we have in Scotland, and I think our principal aim would be to help them do an even better job than they do, than perhaps to seek to create another agency that when they already exist. Final question.
In the bill, there's a requirement on the various agencies to supply information to designated people. Section 3, disclosure of information about criminal proceedings. When asked the police if they're in a position to supply that information in a timely manner to witnesses and victims, they indicated no, that their systems weren't sufficiently subtle to offer that opportunity. I would suspect many of the other agencies involved will be in a similar position. What's the Cabinet Secretary's view of how we're going to deal with that immediately after this bill becomes an act, if it does?
Well, I think what we've got to do is make sure we get the IT systems, because some of this will come down to that, to make sure that we have the appropriate exchange of information. So work is ongoing, because this bill is part of a Making Justice work programme dealing with a whole variety of matters, whether it's technology in courts, whether it's other aspects relating to police and Crown. So there are technical difficulties there, and we have to address the technology. This bill is about the principles and some practical matters, and as I say, we as an administration, we will work with the police to make sure that their systems are appropriate, not just for dealing with victims, but clearly for dealing with all other aspects of justice that they have to address.
I didn't see anything in the financial memorandum that might cover some of these additional costs in terms of IT and so forth for the various agencies. Was that considered, or...?
No, because I think the work that the police refer to me in terms of I6 and other matters are getting done and progressed anyway, and the work that they will do to allow the management of police information systems will, as a consequence, improve matters for victims, but it's being done to improve the system that I think you've commented on quite understandably before. So to some extent the costs are being dealt with in other aspects of policing, but they will have the benefit of improvement for victims.
But they won't come soon?
Well, they'll come
I6.
They are on the case.
On the case as well,
Thank you,
all over the place. Before I move on to Sandra, one of my concerns is the use of the word victim throughout this. I mean, you're only a victim at the end of the day, either because somebody's pled or because we've come to the end of a trial or an appeal. But you're talking about victims in this bill from the point of police involvement. Have you any concerns, for instance, that this is impacting on the presumption of innocence until proven guilty beyond reasonable doubt, and the burden of proof is on the Crown? It may not be for you, but for the public, there may be a perception that this is a victim, even though at the end of the day you quoted the gang, you know, the gangs and somebody giving evidence against another gang leader, but you're taught that would be a victim, and under this bill that person's a victim.
Well, I think we do have to accept it where somebody is a victim of a crime, that they are a victim, whether they are, you know, a beacon of righteousness and truth, or whether...
You're right there. You're not the victim of a crime unless the crime has been proved against you. That's my problem with the definition of this bill, where we talk about victim pre-trial at police stage. right through, whereas there is a point of transition in a case where you do become, you may always be for the Crown a victim, but you're certainly not for the defence.
You could be a victim and there could be no case. Somebody could be assaulted and no perpetrator could ever be traced. No assailant could be found. They would remain a victim. And to some extent, the same definition that we have is accepted within the criminal injuries compensation scheme. Because, for example, in criminal injuries, there doesn't have to be a court case. You have to be the victim of what is perceived as a crime. Whether that assailant is ever identified, whether anything can be proven or taken to court. So we hope that for justice's sake that would happen. But people can be victims without matters ever going to court. Somebody could be the victim. You're the victim of a crime if your car is scraped or damaged. And
you're teaching your granny to suck eggs here. That's not my point. My point is this would be also applicable during a court process, where there is a party in the dock who's accused of a crime against that party, who's being referred to through this legislation as the victim. Now, that gives me concern that we are about the language in here, and I don't know why perhaps we don't have a definition in the bill about when a person is designated a victim and when they're not designated a victim.
Well, I mean, I think that's for the judiciary to balance, and clearly we have always the presumption of innocence. I think the term victim is used, as I say here, in terms of the procedures, in terms of the leading evidence, in terms of evidence before the sheriff and jury, or the judge and the jury. Then doubtless the victim would be referred to either in their own name or unless anonymity was granted. So this is more for the systemic structures, for the bureaucracy that exists, than for the language that would be used in the court, because in my experience the term victim is very rarely used within the precincts of the dock or indeed the witness box. You talk about the individual.
Well, I'm just looking at the fact that the faculty of advocates argued the alleged victim, and that's what we're talking about in court process, should be referred to as the complainer rather than the victim, both before and during a trial. And then, of course, at the end of a trial, one way or the other, they may or may not have been the victim of a crime. Do you see why there are issues for people like myself, perhaps others in the committee, about the use of language, which, Cabinet Secretary, as a practitioner yourself, you know, is terribly important in legislation?
I mean, I have to say, I don't think I remembered in 20 years' practice somebody being referred to in a court trial as the complainer. They were always referred to as Mr. X or Miss Y, or the person that you see seated over there. Some of this seems to me that, yes, there is, you know, language can be critical in terms of the definition here, but I always think that people in the main should be dealt with respectfully. I also think that it's in the best interest of those going through the process that we try to also use language that is understandable. And I do sometimes, you know, we do have to have the term complainer, but to us here, we're aware of that. To a victim, to discuss that actually you're not the victim, you're the complainer, I think might cause some consternation. So I think we can give an assurance to the faculty that the term victim here is used in a broad sense, but it will vary on equally specific matters. In terms of making sure that the balance between what is necessary in the scales of justice for the accused and the victim, we can provide that. And equally, I think I would also be encouraging all in the court system, whether for the Crown or the accused, and indeed for the judiciary, we do have to have, you know, legal language, but wherever possible, we should language that's understandable to the man or woman in the street.
The last point I'll make on that is, you know, I think you've undermined your argument because you said in language that people understand. Now, if people hear that somebody is being referred to as the victim in a case, they understand that that person is a victim, when in fact they may not be a victim at all. So that's the problem for me about this. The language here makes an assertion in simple language that this person has been the victim of a crime during a court process when they may not have been that victim. That's the issue.
Well, I would have to say it has gone through investigation. We have the presumption of innocence, but you know, these things are not brought in a whim and fancy, and there is a case to argue, which is why it is before the court. There is a case there that has to be proven beyond reasonable doubt, which is a very high standard. But it is not brought because a police officer thinks somebody might have done it, and it's not brought on the basis that the Crown think that, well, we'll just do it to satisfy the police. There is an case to be faced, and we have other ways of which we provide protection for the accused to make sure that there is that fair trial. But the word victim, I think, is very sparingly used within the court when evidence is being given. But in terms of its definition in statute and other matters, I do think it's important that we should maintain that flexibility.
Perhaps there should be a definition in the bill then.
Well, we think that the word changes and uses, and equally the terminology and definition that we have is the same that has been used within, I understand, the criminal injuries compensation legislation.
That's a different matter entirely. John, you want to?
Thank you, Convener. I share your concerns about this, and the Law Society also expressed concerns, but they looked at it from a slightly different perspective. I mean, their argument for having a definition is so that individuals knew if this bill or act, when it's enacted, actually applies to them or not, and they've put forward some wording to define victim. I mean, I think what you're saying is you're not minded to accept their argument in favour of defining victim, or indeed their suggested drafting.
Well, I'm happy to reflect upon it, but it does seem to us that we have a definition of victim that is used on a generic basis throughout the legal system in Scotland, that is based as well in Criminal Injuries Compensation Authority, that is understandable to those using it, but we're happy to reflect upon it. But this has come from, I think, the Law Society and the Faculty of Advocates. Others in the system have no issues with it.
Are there any victims who you foresee will not be caught by this bill? Are there any people who are classed as, or how ordinary use of the word language, the use of language victim, are there any victims who will not be caught by the provisions of this bill?
Apart from those who have been the victims of crime and don't come forward to report it to the police or suffer in silence, and we would implore them to report matters. But, you know, we're here to look after, to take the victim as we find them, not to be judgmental. There are other matters in the court system and in the judicial system to address that. It is not, I think, us in laying this legislation to decide whether there's any contributory factors or anything such as that. That's why we have a court system.
Sandra? Sorry, Jenny.
Just briefly on that point, Cabinet Secretary, you said that the term victim was used across the legislation and the criminal justice system, but in fact it's the Criminal Procedure Scotland Act 1995 uses the word complainer, and your example of criminal injuries, that's once a case has been brought and guilt and a victim has been established. So would it not be more consistent to use the language in the Criminal Procedure Scotland Act?
I don't believe so, because a victim is a victim if a crime happens. It might be that nobody saw your car being damaged. It might be that nobody could trace the assailant who assaulted you. Just because matters don't get to court doesn't mean you're not a victim. You are a victim. So, as I say, once you start using the complainer, then everything is dependent upon being in that judicial system. We would prefer that we recognise that there are victims who will have to give evidence in court, and that is why, as Alison McInnes and others have touched upon, there are ways in which we have to provide for them and deal with them differently. But we have to recognise that a victim of crime is not simply somebody who is going to be giving evidence in a court of law. You can be a victim, and probably many more victims of crime will not give evidence in a court of law, and that's why the legislation and definition has to be wide.
But the Act, the bill says, Section 1, subsection 1, each person mentioned in subsection 2 must regard the principles mentioned in subsection 3 in carrying out functions conferred on the person by or under any enactment insofar as those functions relate to a person who is or appears to be a victim or witness in relation to a criminal investigation. So it's within that context.
Then a criminal investigation can be...
Or criminal proceedings.
Yes. You know, if I phone the police today to report that my car has been scratched or my wing mirror has been kicked off, there will be, you know, a crime report recorded. I am a victim of crime. It does not mean that I am going to appear in court if there is nobody able to identify who the accused is.
Now, I've got somebody waiting. I've got John Finney on us, but John Finney's on this point. I'm afraid he's got there before you. John. John? Well, we'll see. John.
Thank you, Convener. Cabinet Secretary, we had a lot of representations from the Children's Commissioner from Children First. And whilst I wouldn't put words in their mouth, I think they would be gravely concerned with regard to children if they were being referred to as alleged witnesses. Would that be your understanding? Alleged victims, I beg your pardon. Alleged victims.
I think that's a fair point that I would agree with. Yeah.
The sort of side of the points have been made earlier. If you report a crime to the police and they fill in the necessary form, or as now the database, you're described as a complainer within that environment. So the police officer taking the report would indicate that the complainer in this case was John Smith, wouldn't be indicated as the victim in this case.
I'm grateful for that. I think we've had a good... Sandra's been very patient. We've aired that. There's obviously a dispute in here about whether or not we're content about the term victim or complainer. Sandra, is something different, is it?
It is. I've found something different. Right. And can I just say I'm awfully glad that I'm not a lawyer or a policeman or ex-police officer. I see myself as a layperson, a punter, and I think we spent about 10 minutes discussing the semantics of whether you're a victim or whether you're a complainer. And I think that says an awful lot for the people.
Yes. It's more than semantics, I'm afraid.
I think it says a lot of why we do need a bill which is clear and it clarifies for the people out there who, whether they be victims or complainers, I suppose we'll decide on that at the end, but it's for the people out there to get justice and understand the justice system. And I was originally going to ask what Graham had asked, because certainly I've spoken to a number of people and I think things have moved on about basically contacting witnesses, complainers, potential witnesses, and I think there's been no appetite from other agencies such as Victim Support for other agency because the experience that's there may be watered down, and I think that bore out in the evidence that we received. So I wanted to touch on that particular point. But now we're on to victims, and John had raised the one about child witnesses or whatever they may be called at the end of this session. And Children First were rather concerned in regards to, it's like, well, a minor amendment, as they say, to current arrangements, basically, which they seem to say their concerns are that children under 12 may be not forced, that's the wrong word, semantics again, but more children under 12 will have to go to court in regards to give evidence. And I just wondered if the Cabinet Secretary and others could clarify that point and whether they agreed with Children First and recognised their concerns in regard to that.
Well, we are taking those matters on board. The change made, I think you've correctly identified by this bill, will not force child witnesses to appear in court, nor will it make significant changes to the current and, we believe, sensible presumption that young witnesses should give evidence remotely. But what it does do is provide that where a child witness has expressed a desire to give evidence in court, and that is for them, that preference is heeded unless there's a good reason why it would be inappropriate. So we believe that this provision will give children more choice, not less, and we think it was a point welcomed in the last occasion by the Children's Commissioner. So it's about building on what we already have. If there is a clear desire by that child, unless there is some good reason, then I do think it should be adhered to, but we do have to have the overarching right of the court to reflect.
Could I just follow up on that particular one? Thank you, Chair. Thank you. I just wondered, Cabinet Secretary, if you think that all children under 12 really have the capacity to make up their minds, or are they advised, helped in some way make up their minds whether they want to appear in court or not?
My experience, I think we've moved on a long way from when I remember appearing in courts, and the method of dealing with a child witness was for the sheriff to sit in the sheriff clerk's chair and take his wig and gown off. I think Tom Welsh and indeed his predecessors at Judicial Studies have moved on from that. Clearly, efforts are made by the court service to make sure that any child understands where, what, how, that circumstances are there in terms of providing for them, and indeed the courts are now much better briefed on the understanding of a child and their ability to be able to decide whether that child should be able to give evidence.
I come back later, not that one, but
yeah.
another issue.
Alison, do you mind if I take, I've got Roddy, Jenny and then you again are on the specific children. The rest of you are not on that. No, okay. Yes, please.
Just pursue this just a little bit further, because the real issue for Children First was the capacity issue, and whether children really understand what they're submitting themselves to when they say that they might want to be in court to give the evidence rather than doing it remotely. Firstly, are there other jurisdictions that you're aware of where children under 12 would give evidence directly in the court?
I'm not. I'm aware of any comparative matters, unless any of my colleagues here can help me. I mean, obviously, there is currently a presumption that children under 12 will give evidence away from the court building in trials concerning certain offences. And what we've got here is a minor amendment to place greater weight on the views of the child who may, for example, wish to give evidence in court to avoid being separated from a parent when this matter is considered. So there is currently a presumption about the situation for under 12s, and clearly the judiciary have a role here in terms of making an assessment regarding the cognizance of the child.
I mean, I'm sure it's well-intentioned, and I understand that, but I would want to be assured that there had been some evidence or research carried out before you opted for this particular option on perhaps the longer term impact of appearing in court. And if that research wasn't done, are you able to have some done in the run up to stage 2 to be able to inform the debate further at stage 2?
Well, happy to provide more information that we have. It would be fair to say that this hasn't been done by my officials without discussions with the Children's Commissioner, with children's charities. So this is based on best evidence that we have from all those who are involved with children as to appropriate methods, and that's been built up over many years in terms of how we get to matters. But, sorry.
I don't have the official report here, but it's my recollection that Children First were surprised and felt that they hadn't been consulted on that. So I'd certainly be grateful if that was...
We'll provide that information.
Thank you. I now have Roderick, Jenny, Alison and John Lamont. And you're out of it now, right? Okay. Roderick, Jenny, then John Lamont.
Morning, Cabinet Secretary.
Morning.
I've got a number of slightly unrelated questions. First of all, can I just kick off with restitution orders? We heard evidence from the police representatives from ASPS and the Police Federation, as well as, I think, written evidence from the faculty that the restitution orders should be considered to be extended to other people in the emergency services, not just policemen. Any thoughts on that?
Well, we don't rule that out. I mean, clearly the overwhelming majority of the uniformed and other services who suffer assault tend to be police officers, but I'm aware of the dreadful incidents that do arise others. I think the situation relating to the police is we already have an organisation to which it can go. I don't preclude looking at these matters. What I wouldn't want to do is create something where the administrative cost and the administrative burden of running it would outweigh any benefit, because after all we already have compensation orders that can be given by a court. So I think what we should do is proceed with police, who tend to be the majority of the victims, who already have a situation where the individuals contribute into it, but where we can provide treatment and restitution for them. I'm happy to look at other matters in due course, but I would not wish to burden some organisations with perhaps establishing something where the running costs would outweigh any benefit for the individual who had suffered.
Thank you. Moving on to a different subject, perhaps I should refer to my register of interest as a member of the Faculty of Advocates. We heard evidence from the faculty that consideration should be given, particularly in kind of sexual history, Section 275 applications, to the participation of the victim or alleged victim or whatever in that process, and the possibility, therefore, I suppose, of that victim being legally advised. Any views on that aspect?
This is something that's been raised by both the faculty and Rape Crisis Scotland. I think have raised this fairly recently. I mean, obviously, we're open to getting further detail from them. I mean, from our perspective, I think we'd need a bit more clarity on what exactly that legal representation's role would be in the process, and would it just be limited to those application hearings, as you've said?
So, but I don't want to speak for the Faculty of Advocates on that point. Moving on to the third one, in terms of special measures to date, is there any kind of academic evidence reviewing that and saying, has that led to best evidence being given? Have we got any evidence on the use of special measures to date?
There's been no extensive research carried out in terms of special measures in Scotland. There was a report published in 2008 covering the initial implementation phases, so the 2 years before the 2004 Act and the 1 year after that. That did find that the Act had raised an awareness of vulnerability, as well as raising the use of those special measures to help vulnerable witnesses. However, the main thing it highlighted, I think, was that there was a bit of a lack of data in how many special measures were being used, how effective they were. And I think that's probably still a bit of an issue at the moment.
And finally, just on the question of closed courts being used as a special measure, but ruling out the accused right to be treated as vulnerable and to have a closed court. Any kind of further comment on that, or the reasoning behind that, Cabinet Secretary?
Well, I think there are ways in which the court already has powers and rights to address the challenges that face those who are accused. This bill is driven towards improving matters for victims and witnesses. Clearly, if there are thoughts that people have regarding changing the current scales of justice or what we should be doing in that, we'd be happy to look at it. But we already have methods of providing some matters to alleviate issues for the accused, but we would look at that, but I think it would be better looked at separately.
Okay, thank you.
That's you, Jenny, to be followed by John Lamont.
Thanks, Convener. Cabinet Secretary, I have two questions, one on families of victims and one on witnesses. But if I could turn to witnesses first. Over the last few weeks, we've been aware in the press and in the Chamber of issues with witnesses coming on to give scientific evidence. And clearly in our courts, the better understanding there is of the witnesses who give scientific evidence, then justice is better served if there's a better understanding among the jury, among the judiciary, and indeed amongst the prosecution and defence lawyers. There's been a number of proposals raised to improve the understanding of scientific evidence and the procedure for scientific witnesses in our courts. Would the Scottish Government consider tabling an amendment to this bill to provide for the accreditation of scientific witnesses in our courts?
Well, I think we already have procedures that are available within our court if there's any doubt or dubiety. Equally, I would put on record my gratitude to the Lord President for, I think, taking a very bold and appropriate step to clarify matters. So I think our position is that legislative basis is already there to ensure that we get the correct balance. I will be meeting with the Lord President tomorrow, and I'm doubtless we'll be discussing this matter, but the system already exists in Scotland. We do have the procedures which these matters can be tested if it's so desired.
I mean, I think the feeling amongst the experts is that the current procedures are not sufficient to improve understanding of scientific evidence in our courts. And this is something that the English Law Commission has looked at recently, and it might be something that the Scottish Law Commission might want to look at too. But my specific question was on an accreditation process, which I don't think would have any resource or budgetary implication, but would be, I think, a very good measure in giving our courts and our prosecution defence lawyers and the public confidence in the scientific evidence they were hearing. I mean, would the government consider looking at just a simple accreditation system for scientific witnesses in this bill?
Well, I think if you want to specify who would accredit and what basis and who would staff the organisations that would be necessary to provide the accreditation, I'm more than happy to consider it. But we do have criminal procedure matters where if there's any doubt or dubiety over a witness's competence or capability, evidence can be led. So I think we already have that. I don't think that additional bureaucracy is necessary, but I'm happy to take on board any thoughts that you may care to send to me.
I mean, this is more a preemptive suggestion, so the accreditation's there so it doesn't come to the point, hopefully, that you're talking about, where these procedures kick in and make it more efficient and take up more time of the court. But hopefully...
Why sheriffs or judges quite often in inquiries have to sit with lay advisors, because judicial knowledge tends to be legal, not tend to be scientific, and I open to suggestions about how a judicial system where you've had a life training in law would qualify you to perhaps decide whether somebody was an expert in a scientific field which you had no knowledge of. Now that may, as I say, envisage some organisation would have to deal with it. Normally what you do is you put the witness to the test in terms of running through the evidence of their qualifications, what they've done. That's how we deal with it in the current system, and we can preempt matters, and these matters can, in procedural systems that we have in Scotland, already be dealt with if there's any doubt or dubiety over the individual's competence.
I mean, I think just to finish on that, Cabinet Secretary, I mean, I think you hit the nail on the head that there isn't sufficient understanding amongst the judiciary of the scientific evidence, and that's one of the reasons that one of the proposals I put to the First Minister was for scientific advisors in the court. But like you indicate, if that's something you'd be open to consider, then that would be very welcome. Can I turn
before you move on? Is that within the purposes of the bill? I mean, I'm looking at the purpose of the bill. An Act of the Scottish Parliament to make provision for certain rights and support for victims and witnesses.
Well,
I tend to think
most of these matters are matters, as I say, I will be seeing the Lord President as part of an ordinary catch-up in meetings. I'm grateful for the steps he's taken. I'm happy to engage with the Lord President. Equally, I'm due to engage with Professor Sue Black when she is back, and have been in correspondence with her.
Thank you, Cabinet. I mean, just to clarify, Convener, I haven't raised this spuriously. I have taken some legal advice and believe that it may be competent within the bill. So we can certainly investigate on that basis.
I just took my own legal advice there. It may or may not be within the purposes of the bill.
Can I turn to an issue concerning the families of victims, Cabinet Secretary? We heard evidence last week from from families of people who had died in road collisions, in fatal accidents. And that campaign group is looking to have a right to information from police and the Crown Office enshrined in the law. And this is also open to a potential amendment in this bill. Now, we understood from the evidence last week that families actually do have a right under current guidelines to the information, but really in practice they are not receiving it and they're not being told that they do have that right. Would you consider giving comfort to these families by having that right on request, because not all families want the information, but for those who do, to have the right on request to that information enshrined in this bill?
Well, I think I'd first of all put on record my tribute to Margaret Decker and her colleagues in Skid, who have done a remarkable job, I think, in raising the issue, pushing both the administration in which I serve and previous administrations, and I'm grateful for them. Clearly, the Crown Office and Procurator Fiscal Service currently release the investigation documents to bereaved families who request them, unless criminal proceedings are ongoing which could be prejudiced by releasing the documents. And in these circumstances, release will be delayed until the trial is concluded. In releasing the papers, as you correctly says, sometimes some families don't wish to receive such matters. We think that there probably is the right balance here, but we're happy to discuss with the Crown Office and Procurator Fiscal Service as to whether there's further matters that can be done. We don't believe it's necessary for there to be a statutory right, as the Crown Office already, as I say, do that. But I'm happy to enter into discussions with the Crown and to return to the committee with their views.
Just to press you on that, I mean, we discovered in evidence last week that they don't just do that. They don't just release the papers. And there's certainly not enough information goes to the families to tell them that they can request that information. The enshrined right in law is really to give them that protection that will allow them to make that request. Is that something you would consider for these families?
I think I'm happy to engage with the Crown about ensuring that the appropriate level of information, wherever possible, is given. There are things that the Crown, I think, quite correctly disseminate. Sometimes the information, the evidence, will include distressing photographs of pictures of the deceased. You would not wish to send that in a large pile of documents to somebody as part of their statutory right. I don't think that's what is envisaged. So what I'm happy to do is to engage with the Crown. I don't believe a statutory right is necessary, but I've no doubt there may be further improvements that the Crown can and should do, and I'm happy to liaise with them and to return to the committee, because I do think we have to ensure that we take into account the balance of the right to the accused, so that a trial is not prejudiced, but equally that we also perhaps use some common sense that before some information goes out, that perhaps it should be screened so it wouldn't be horrific and distressing.
Thank you. Thank you.
John Lamont, please.
Thank you, Convener. My first question relates to the victims' surcharge, which I believe will apply to all offenders who are given a fine. I think most of the victims groups that we've heard evidence from have welcomed this, so that's, I think, a positive move. I just wondered who's going to be responsible for collecting this surcharge, and how is the Cabinet Secretary going to ensure that this doesn't simply add to the backlog of uncollected fines which already exist?
Well, I know sometimes in Scotland people prefer the glass half empty than half full, but on this specific matter, court fines are at 86%. I think you've had assurances for Cliff Binning. I think we anticipate this matter will be dealt with by the Sheriff Court Service, and they'll do an outstanding job in collecting this, as they seek to do in collecting fines. There are people who are reluctant to pay, but with the good support and the willingness, and I paid tribute to the DWP, with further information now becoming available, I think matters will get better.
How much is currently owed in uncollected fines?
I don't have that information before me, but as I say, I think we're at 86% collection rate.
That wasn't quite my question, but my second question relates to automatic early release. Now, the bill provides for information to victims and also gives them a role to a certain extent in the sentencing of offenders. Now, one of the great frustrations I hear from a lot of people, from my constituents, is the practice of automatic early release, and I'm conscious that the SNP have had 2 elections where they've made a commitment to abolish automatic early release. I just wondered if you see this bill as a missed opportunity.
Section in the bill, but never mind.
That's my point. Do you see this bill as a missed opportunity to have the abolition of automatic early release?
No, I think this bill is a welcome opportunity to improve matters for victims and witnesses. I'm aware of the long-standing issues relating to automatic and conditional early release, a matter brought in, of course, by a Conservative administration long before we even entered into administration. And I think you can say that we will be looking to work through matters as and when appropriate in criminal justice bills. We prefer to keep our focus here on who for, I think, too long, as I mentioned earlier, until Ailey Shangelini and Frank Mulholland have driven matters forward, too many people who were perhaps viewed without the respect they were entitled to, and that is the victims and witnesses of crime.
So just to clarify what you've just said, is that commitment then to bring forward an abolition of automatic early release in other criminal justice bills that are coming before this Parliament in this session?
We have a manifesto commitment. We also are building upon the advice that we got from Henry McLeish, which was that couldn't be addressed until prison numbers had been reduced. But there are matters that we consider, and we always look to make sure that Scotland is as safe as possible. So at the present moment, we have inherited the Conservative administration of many years ago who brought in automatic early release, but we are happy to discuss, as I think I've just signed off a letter to your party leader, happy to engage with these matters.
The party leader will share this information with Mr Lamb. Can I return to the bill specifically and section 5? A very important section in certain sexual offences which are specified in subsection 5 of the victim's right to specify the gender of an interviewer, which is, as my old history teacher used to say, a good idea. However, it's not always going to be practicable, and I note that in section 5.4, the investigating officer need not comply if complying with it in the subsection B to that, it would not be reasonably practicable to do so. So, you know, given that we, let's say, very rural areas and so on, and you know, it's not just going to be, how possible is it going to be to actually put this into practice, you know, given the logistics in certain crimes of taking evidence early and having an officer of the appropriate gender or even culture present to take it?
Obviously, that's fundamentally a matter for the police, but it does seem to me that part and one of the significant benefits of the single service is that we're able to move towards a national rape investigation unit, which is long overdue. We have a specialist crime division that has divisional areas. So I think the expertise is there. There is a consciousness of the not just desirability, quite often I think it's necessary for the victim. So there may be instances where it was not possible, but I think they will be few and far between, because I think the police are working on the basis of making sure that they have ready access. The first person on the spot may be a police officer of a different gender, but I think the single service, the establishment of a national rape investigation unit and the specialist crime division will allow for the police to be able to ensure that at very early juncture the appropriate person with the relevant skills and indeed the gender of choice can be provided.
Now, I hear that and I think that's reasonable, and this is about interviewing, but what about forensic examinations? Rape crisis want that extended to forensic examinations. Would you be prepared to do that?
Again, I'm happy to look at that. Some of these matters, again, are even more one step removed, because the investigations would, I cannot direct the police, only the Lord Advocate can. I'm simply going on my knowledge and discussions with the police, and clearly quite often this would be police surgeons who are, again, one step removed from the police. But again, as I say, I think what we have seen is a change in culture. A recognition that how the person is investigated, by whom the person is investigated or examined, all of these things matter. So I think I can give you an assurance on behalf of Police Scotland, police surgeons, that we will ensure that we all work together to, wherever possible, provide for this, because it is traumatic, and anything that can be done to reduce the distress is important.
It might be possible then to amend Section 5 to extend it beyond interview to examination.
I mean, I'm happy to look at it, whether we need to amend the legislation or whether we just need to try and ensure through proper guidance. Nobody, I think, that I'm aware of in the police service, in the Procurator Fiscal Service, in the health service dealing with these matters would seek to compound the agony. So what we are seeking to do is to have some flexibility for a dreadful incident arises where, forever, shift pattern, locality, geography, but, to immediately be aware that you should be asking the victim, what can we do for them? And if they say that they would like a doctor of a specific gender, then we should seek to provide that.
Yes, I was just going to leave that there. This is a supplementary.
It was basically on compensation orders.
Yes, okay.
I did try and get in, but it moved on from Rod when he met. No, it's all right. Rod had mentioned it. It was basically, on that particular subject, and Scottish Women's Aid have raised, a concern they have about the compensation orders that victims would have the right to refuse, because they're obviously concerned if there's a compensation order in a rape trial, or whatever it may be, they would have the distress of, contact with the accused. I just wondered if they would look at the flexibility there, and these people's views would be taken on board before a compensation order was granted.
Absolutely, we're anticipating that if somebody did not wish it because it would throw salt in the wounds, then that should not be done, and we will ensure that appropriate guidance and action is given.
Thank you.
Well, I hate, if I say this, I know somebody's going to put their hand up. I'm just going to say, as there are no questions, I move quickly on and say thank you very much to the witnesses for your attendance, comprehensive questioning session, and we now move on to item 3 on the agenda. And I'll just move straight on to, because we go into private session pretty quickly. Our next item of business is consideration of the Police Service of Scotland Amendment No. 2 Regulations 2013, SSI 2013, Week 125. This instrument is subject to negative procedure and makes corrections and clarifying amendments to various regulations, setting out conditions of service for members of the Police Service of Scotland. The Subordinate Legislation Committee wished to draw the instrument to the attention of the Parliament on the grounds that it should have been issued free of charge in accordance with the Scottish Government's usual policy and when issuing purely corrective instruments. Do members have any comments in relation to this SSI? No comments. Are you content to make no recommendations? Thank you. I think we've gone into private session, haven't we? Right, item 4, we now move on to the next item, which is consideration of a draft annual report This report summarises the work of the committee in the last parliamentary year. Members may wish to note that there's a prescribed format and word limit, I think that says don't touch it, to the report. Do members have any comments in relation to the draft annual report? Roddy is pulling a face that I feel a comment is coming.
Well, no, well,
okay, it's fine.
I had not realised that there was a prescribed word limit, and that's why I kind of thought that the paragraph 40 of human rights was a bit peremptory and we could have done better. But if there is a limit on words, perhaps I'll withdraw that.
How kind. Thank you very much. Right. Oh.
Just one thing. I wondered if did we not do a round session sorry, a round table session on speech and language?
Yes.
Speech and language prisoners, but also if we could include that, I wonder if we should also make note of the concerns that have been raised in the committee regarding the Offensive Behaviour Act, which obviously was passed before the remit of this annual report, but certainly questions have been raised in committee about the Act in practice.
Yeah, I think the problem is we haven't done any work on it. What we're doing is reporting the actual work. All we did was had a discussion and correspondence out, but we didn't do any work as such on it. And I think that's the point about our report. But you've got it on the record, right? So that would come up next year, right? We now move into private session. And that's us. And you can get your